Everyone. Welcome to Monday, September 23rd, our effective HIPAA compliance date. Thank you for joining me on today's webinar. I'm going to take some time today, hopefully not more than about half an hour, to take you through the requirements on what you should have in place as of today. Now, I haven't seen that many presentations that are doing exactly what I'm going to do today, which is going through the actual specifics on what you should be implementing. Many have been more so on broad-reaching overview changes, which we will discuss to a degree, but I'm going to start specifically with our notice of privacy practices today. And then I'm going to go into what constitutes a breach under the new HIPAA law, and we'll go through business associate arrangements and ramifications of noncompliance. And then we'll go through some common questions and answers. And as I said, I'll try to keep it to within half an hour so you can all enjoy your lunch break and get back to work or get back to your lunch break. For those of you who do not know me, and this is our first interaction, I apologize that it's one way, but that's the nature of these webinars. That's a picture of me. I'm Jennifer Kirschenbaum. I'm a healthcare attorney, and I am the managing partner of our healthcare department at Kirschenbaum & Kirschenbaum. We are a 15-attorney firm, mid-sized firm based in Long Island, and we help healthcare practitioners with pretty much everything that they have going on, from real estate, transactional, regulatory compliance, audit defense, you name it, we pretty much do it, and we have a big litigation practice. So to get moving towards today's topic, changes to our privacy notice. This is the major shift of actual documents that you need to update and print out and have available for patient use. And these are the four main changes that have to be incorporated into your privacy notice if you've not done so already. Now, for many of you listening, you may think, well, these four things are not relevant to me, and I'm not going to be soliciting patients for marketing. I have no intention of selling their information. I don't do any fundraising where I contact patients, and I'm not a psychotherapist, and I don't have their notes generally. That is completely irrelevant to your responsibility to comply with the new HIPAA requirements. Every practice nationwide that qualifies as a covered entity is required to have these provisions that we're going to go through one by one in their notice of privacy policy as of today. And you may say, well, I haven't heard of this. I haven't had an updated privacy policy in some time. I don't know what a privacy policy is, Jennifer. Well, that's fine, but it's not going to fly moving forward. The Office for Civil Rights, who are the HIPAA police, as I call them, has been a dormant government agency up till this point in time, and now is operating under a very new mandate and is going to start doing compliance audits to ensure that doctors are actually complying with these new requirements, and they will be checking to make sure that you have a proper notice of privacy practices for your patients. Okay, so let's start going through our requirements here. Marketing provision. You are now required to have in your notice of privacy practices a provision that explains that the practice is required to obtain an authorization. Now, this would be a separate authorization for any use or disclosure of protected health information for marketing purposes, except if the communication or marketing is done face-to-face with the patient in the office, or a promotional gift of nominal value. I get asked all the time, Jennifer, can I give away a free iPad to patients and have a raffle? Sounds like a good idea. It can increase patient activity at the practice. It's good for morale. But as we may or may not be aware, that is a kickback to your patient population. And you are not allowed to give away anything of more than nominal value to your patients. Medicare rules state that you cannot give patients more than $10 worth of value at any given time, so it has to be de minimis. And each patient cannot receive a value of more than $50 per year from the practice. So for those of you listening that have these types of promotional giveaways going on, you may want to consider rethinking because it's an area that you may be willing to cut that might be causing you exposure that's not necessary. Marketing, just so you know what it means a communication about any product or service that encourages recipients of the communication to purchase or use a product or service. It does not include refill reminders or other communications about drugs or prescriptions the patient is on. So that's just so you have an understanding on what would constitute marketing. And an additional authorization would be required if you are engaging in marketing discussions. Our sale provision that has to be included into your Notice of Privacy Practices as of today must cover that the practice must obtain an authorization should it sell any protected health information or gain from any such sale. Now, this does not apply where the practice can sell, where it's used only for research purposes, and the only remuneration is reasonable cost-based fee to cover the cost to prepare and transmit, and where transmitted for the sale, transfer, merger, or consolidation of all or a part of the practice, and for related due diligence. So what does this mean? Well, I can tell you that I don't necessarily agree with the regulators on what they put in place here, partly, because I think the first part of why you don't need an authorization for sale purposes when you're selling patient information for market research, I'm not really sure what their thought process was. But we've thoroughly digested the language proposed and adopted by the federal government and now incorporated into the HIPAA rules. And for whatever reason, this is what they put in place, and this is what you're required to have in your Notice of Privacy Practice. Now, it does make sense and it's beneficial for every practitioner out there that if you were to sell your practice, we do not have to worry about obtaining an authorization. So that is a good part of this provision, and this language does need to be incorporated in. Our fundraising provision is to ensure that a covered entity is not using or disclosing any patient information for fundraising purposes unless we get an authorization and we have some additional safeguards in place. So a statement needs to be given regarding any fundraising in the policy, your Notice of Privacy Practices policy that we're talking about now. And with each fundraising communication to each individual, there must be a clear and conspicuous opportunity to elect not to receive any further fundraising communications at all. So in other words, we need to have a comprehensive opt-out option for any patients who are being contacted for fundraising purposes. I know that many practices, again, as I said before, do not engage in this type of activity. That is irrelevant to the requirement that your Notice of Privacy policy must contain this provision starting today. Psychotherapy notes. This provision has caused a little bit of backlash from the clients that we've worked with to implement new policies because they simply state, it doesn't happen. I don't get these notes in my records. I don't usually have cause to request them, and I don't like being responsible for maintaining them. Again, irrelevant. You still have to adopt this language into your policy to ensure compliance. Your Notice of Privacy Practices, as it states, must have a statement talking about your allowed use and disclosure of psychotherapy notes. This is regardless of whether or not you're creating these notes. Okay? So reasons why you would not have to have an authorization signed for use of psychotherapy notes, in case you are interested, is if you're the originator of the psychotherapy note, if you're using the notes for training purposes, or if it's disclosed related to a government or legal proceeding. I'm not going to spend much more time on this because I know it's not relevant to everyone listening. If you have any questions specifically about psychotherapy notes, you can feel free to email me at the conclusion of this webinar, and I'll be happy to discuss with you offline. So we understand that, and I'll just go back to the beginning, the first page, so you can see of our change of notice of privacy practices. The marketing, sale, fundraising, psychotherapy note provisions must be included in your policy as of today. So the next thing we're going to discuss is, what do I do with a new notice now that I have adopted it and it's in compliance? Well, you have to have the new notice of privacy practices available at your treating location. I recommend printing out a stack. Don't have to go crazy, but you should have available 10, 15 of your policy in your waiting room, somewhere accessible the patients can see it. You should post the notice in a clear and prominent location, this is required, where it's reasonable to expect patients to actually see it. The notice must be available upon request on or after the effective date of any revision, which is hopefully today or sometime this week. There's always a grace period, so if you don't have your new notice available today, I would recommend that you do try your best to get it together and have available in the next couple of days, certainly weeks. If you have a website, I recommend posting your new notice on the website. Now, here's the kicker with the notice of privacy practices. You haven't heard me say that your patients have to sign off on it. Your patients do not have to accept a receipt of the notice of privacy policy. They do not have to actually view it. They must be given an opportunity to review it, and if they have any questions about how their protected health information can be used or disclosed, they must have an opportunity to get access to it. I would recommend immediately upon such a request. Now, I haven't gone into the details on what's actually required in a notice of privacy practices other than our new requirements, because that discussion can take several hours. If you do not believe you have an up-to-date privacy policy, now is the time to be clear that you do. And if you have no idea what document I'm talking about, it's the document that discusses your allowed uses and disclosures of protected health information, which would include any patient information. And that's for treatment, payment, and operational purposes, what you can use it for. And those definitions have changed under the new rules that have been promulgated and are now effective. We do have other webinars available on the website that go into a little bit more in depth on what that means. But for those of us who are the majority that do have a proper privacy policy in place at the moment, I'm not going to spend additional time on it. I'm going to try to cruise through. We're already halfway through our webinar for the allotted time for half an hour. So you can check out our other webinars to go through some more information on that. This is very, very important, something that I would like all practice to have adopted by this point or in the next coming weeks. Breach notification. This is a real key to our new requirements under the rules. Previously, whether or not there was actually a breach at the practice level was determined as to whether or not an individual was actually harmed as a result of any unauthorized access. That standard has been thrown out the window. And because of what's been adopted now, every practice, in my opinion, is required to engage in training of practice staff, and this goes for business associates as well. All staff members of business associates need to understand what constitutes a breach and what their responsibility is if they are engaged or aware of a breach of protected health information, okay? So let's go through it together. I know it's written out, but a breach means any acquisition, access, use, or disclosure of protected health information in a manner not permitted under the HIPAA rules. Now, just to be clear, protected health information is any individually identifiable patient information. For instance, a name, a social security number, a license number, a picture. All of these things constitute protected health information. And if any of them are accidentally used or disclosed inappropriately, we need to follow these new guidelines. A breach excludes where a practice member or business associate has unintentional access within the scope of authority and does not result in further use or disclosure. So Steve is the one working on patient records, and Tammy, who also works in the practice, has access to the records. That is also an authorized individual. There's no additional use or disclosure. That would be excluded from a breach. Disclosure from one authorized person to another authorized person. This would be our physician referral scenario. Dr. A is sending a record to Dr. B on behalf of the patient. Both are authorized persons. Both are treating the patient. Patient has signed both of their privacy policy consent forms. Third, where access by an unauthorized person to whom the disclosure was made would not reasonably have been able to retain such information. This is an example I've used in prior webinars. This is something that happened. I had a billing company that accidentally had their clearinghouse post information from Practice A on Practice B's site. That information was available for a brief period of time. It was not printed by any party. It was not retained by any party. So we determined that there was no breach. Here are risk assessments that are now in place to determine breach. Where there is a low probability that the protected health information has been compromised based on a risk assessment of at least the following factors, we can determine that there was no breach. And these are our factors that we would have to determine. The nature and extent of the protected health information involved, including the types of identifiers and the likelihood of re-identification, the unauthorized person who used the protected health information or to whom the disclosure was made, whether the protected health information was actually acquired or viewed, and the extent to which the risk to the protected health information has been mitigated. Now, just to be clear, and so that this is not just me reading off elements that you're not really sure how this comes into effect. If there's a breach at the practice or at the company, if you're a business associate listening, what this slide is telling you is there must be an internal risk assessment performed if there is any use or disclosure of protected health information that is not explicitly authorized. The risk assessment should be done in writing. There should be a record that it was performed, and the factors should be explained on why you determine whether there is or is not an actual breach. You may not want to do this internally. You may feel more protected, because you will be, if you consult with your healthcare attorney and explain the circumstances of the breach and have your attorney prepare your risk assessment. That way it is objective, it is documented properly, and you can feel more comfortable that you have addressed the situation and mitigated your potential exposure. I encourage each of you to adopt a policy that employees who fail to report potential breaches may result in termination of their employment at the discretion of the employer. We cannot cover up mistakes, and we're going to get to why in a couple of minutes. The risks now under the new law are too high for potential exposure for fines and audit. So it's very, very important that we adopt a clear employee stance that everything must be reported. And we want to have an open reporting mechanism, possibly where there could be anonymous reporting if need be, or encouragement for reporting. And this is just the state of affairs, and I recommend that every employer considering adopting these tactics. Business associate arrangements have changed, and as of today, I would want to encourage each of you to take a look at your arrangements and make sure that you have a valid contract in place. Okay, so for who is a business associate, the new rule is including anyone who creates receives, maintains, or transmits protected health information for claims processing or administration, data analysis, processing or administration, utilization review, quality assurance, patient safety, billing, benefit management. To sum it up, it's pretty much everyone who doesn't actually work for your practice that has access to your protected health information, and such access is not incidental, is not accidental. For instance, your internet service provider is not a business associate. Your bank is not a business associate unless they have substantial access to your system and can get into your medical records. So your billing company clearly is a business associate. You are required to have a contract with your business associates. So please make sure you have that, and make sure you take advantage of the ability to put in protective measures, such as an indemnification provision, which means that either party may be indemnifying the other, preferably, depending on who I'm representing, the party I'm representing getting protected against abuses or mistakes or negligence of another party, and having the responsible party take responsibility financially for any such mistakes. The minimum necessary standard, which has always applied to covered entities, meaning medical practices and facilities, now, according to this language, applies to business associates. All of your business associates and all business associates listening are now legally required to only disclose such information as is the minimum necessary to get the job done, whatever that job is, on behalf of your clients and on behalf of patients. So for those of us who have been a little willy-nilly about disclosing whatever we have on file to the billing companies to ensure payment, we may want to review our procedures and make sure that we are adhering to our minimum necessary standard. And I understand that means something different for everyone, and if you'd like to speak about it in more detail, we can do so offline. There are changes now to liability for agents, which is a big deal. If you are subcontracting out or using a third party to do any service for you, and that person does not have a defined role by contract, but is just working for you on an assumed basis and on your behalf, you will be responsible for any exposure that agent gets you into or themselves into. So what does that mean? It means that we want to have a contract clearly delineating job function for anyone who's working on our behalf. And that's any contractor, subcontractor, similarly your employees. Everyone should have a job description, and we should be clear what their responsibilities are and what they're going to be responsible for if they make any mistakes on your behalf. So we really want to define liability here and exposure. I'm not going to spend a lot of time on this, non-compliance civil monetary penalties, because the fact that you're on this webinar and attempting to comply shows me that you're doing the right thing. The reason why compliance is so important is because the penalties are now pretty substantial. So you can read them for yourselves, but we'll go through them very quickly. There is 4 levels of violation now under the new law. The agency, the Office for Civil Rights, is now required. They must impose a fine if there is something that has gone amiss at the practice, assuming that it cannot be corrected within 30 days. Okay, so reasonable cause, just so you know what it is, because you're reading here under certain violations. First violation, if a covered entity did not know by exercising reasonable diligence, would have known, this is where most people are going to fall under because most people try to comply, then it's going to be a small fine. Second level is if the violation was due to reasonable cause, which means any act or omission where you knew or should have known that you were in violation, but in which you did not act with willful neglect. Willful neglect comes down to our third standard, where a penalty is not less than $10,000. Okay, so willful neglect means a conscious, intentional failure or reckless indifference to the obligation to comply with the HIPAA rules. I know that no one listening is going to fall into that category. It is a significant burden. You would have to try to not be in compliance, essentially, or flat out ignore your responsibility to protect patient information. We now have one protection is that the imposition of penalties will not happen if a violation is corrected within a 30-day period. So there's some protection there. Here are factors determining a penalty that the secretary will determine of HHS, who is the one responsible for imposing penalties. And the secretary always has discretion to lower or adjust penalties. So they're going to look at the nature and extent of the violation, the number of individuals affected and the time period during which it occurred, the extent of the harm resulting from the violation, whether there was physical harm, financial harm, or a harm to an individual's ability to obtain health care, the history of prior compliance of the practice, whether this is a first violation, prior attempts have been made to correct, have they responded to technical assistance from the secretary, which that means when you engage with the secretary of the Office for Civil Rights, it's different than dealing with, say, Medicare. You actually can get a person on the phone and they try to be fairly helpful. So if they tell you some technical changes you can make to the practice and you've implemented the same and you still had a breach resulting the next year, well, guess what? You may get a lot of credit for the fact that you've implemented a compliance plan and that you've listened to what the secretary asked you to do, and in which case they may decide to lower any potential penalty or maybe even forego a penalty in its entirety. The financial size of the practice facility will absolutely be taken into consideration. When you read these dazzling headlines of a hospital being fined $900,000 for releasing a celebrity's patient protected health information, that amount of money is being fined to penalize the hospital, which is a larger institution, has more money in its coffers. If we're talking about a general practitioner's office that's grossing $500,000 to $600,000 for the year, obviously that fine is going to be pro rata applied, and the numbers would be much, much lower. Another element I want to highlight for you on why compliance is extremely important is the Office for Civil Rights has now been authorized to participate in what's called agency share. When they used to get involved, they were very pleasant to deal with, and the information was contained and confidential. Now, if they find that you're doing plenty wrong on HIPAA, they may want to refer you over to Medicare for the Office of Inspector General to take a look, and that's a big problem. I've highlighted a few questions that I've received in implementation, and we'll go through them pretty quickly because we're almost at our time period here. So how long do I have to respond to a patient request for records? The answer to this is 30 days. This is new. There used to not be a time requirement, but now there is according to the law. Why is this very important? Patients are not patient, and if they ask for their medical records that they need to go to another provider or for any other reason, maybe they're leaving your practice, this is an easy area to get reported. My goal as your counsel is to keep you off the radar and to make sure that we don't have to deal with the Office for Civil Rights for any type of audit. If a patient contacts the Office for Civil Rights, they are required to investigate. So an easy way to get reported or have a complaint made about you is to ignore a simple request. If for some reason there's a hurricane or an act of God that you cannot get records out to a patient within 30 days, please be sure to contact the patient, document in writing what the delay is or when you believe you will have the request together. Maybe you're waiting for duplicative x-rays from another company that lost the request, whatever it is. Make sure to keep open dialogue with the patient so that way it's not you just not responding to the request for records. Also on this, you are now required, if you're operating electronically, to provide electronic record production to patients. Can I charge patients for responding to a record request? Yes, you can, but I want to warn you here. Again, you need to be able to substantiate the fees that you're charging, and you want to be really careful that you're doing so in a transparent manner because patients do not want to pay. They don't want to pay their co-pays. They don't want to pay for their services that they're receiving. They don't want to pay for balanced billing, and they certainly don't want to pay for their record. All of these are legitimate things for patients to be charged for. I'm going to be the first one to tell you that. With the fees for medical record production, please be sure that you can document and justify what you are charging them. You are allowed to charge for labor for copying protected health information, whether in paper or electronic form, supplies for creating the paper copy. New York State has a 75-cent per page payment. That's for the actual supplies. Postage, you're allowed to charge for, and also for preparing an explanation or summary. Now, as I said a couple of seconds ago, be sure that you can justify the expenses that you're charging. Make sure that you create a detailed invoice similar to what you receive from your attorney. Make sure that you have a line-by-line explanation as to what you're charging for the production of medical records. Many of my clients tell me, Jennifer, it's just too annoying. I don't want to put it together. The patients complain. I'd rather just give them the records for free. Well, that's you taking a loss, and I don't recommend doing that. You should be charging for the production. Just make sure you can justify the expense. Who should be our privacy officer? We covered this in the listserv just last week. An appropriate representative of the practice, assuming the responsibility of staying up to speed with HIPAA changes and responsible for patient-protected health information issues, is who should be your privacy officer. If this individual is an administrator and not a practice owner, that is fine. If the administrator would like to have some sort of contractual protection with the practice that they're not going to be held responsible, that is something you should contact your attorney about, and I think that it's not necessarily a bad idea, and it should be a defined role. If there is no clear administrator who's been with the practice for a very long time, who has this capacity and ability and who's handling these issues, then it should be the physician owner or a physician manager who is responsible to serve as privacy officer. And this is dependent, of course, on each individual practice on who should be the appropriate party. So where can I get a new notice of privacy practices? Our website is a great resource. I'll actually show it to you quickly. We do charge a flat rate for the privacy policy. This is our website order form for those of you who have not been here. This is our prepaid legal plan. Our HIPAA documents are here. We charge $140 for the notice of privacy practices. It covers our cost preparing it for you, and we send it out with the provisions that we've gone over today. We do have a breach notification policy that I recommend adopting just because it'll explain to your staff and allow for training purposes. None of these we try to make money off of. It's just covering our costs to get you the information that you need to make sure you're up to speed. So you can order directly off the website if you need any of these policies. The website is, if you actually go to www.healthcarepracticecompliance, pretty sure that's it, compliance.com, it'll take you directly to our website, and you can order from there. So this is what I've prepared for you guys today. I hope that it was educational. Today you will need a new notice of privacy policy. I recommend a breach notification policy to make sure that you and your staff are up to speed. These are the main changes. The notice of privacy policy, which I'll add, again, we talked about the patients don't actually have to sign off on that. What they do have to do, or I recommend, is signing off on a consent form that they agree and acknowledge that they've received or had access to the privacy policy. And what we put that in, we combine that with the consent for the practice to contact the patients via email and leave messages, and we put it all into that one form. I'm aware that we don't want to hand out additional information to our patients. We want to have as few forms as possible when they come in. The demographics form, patient history should be one. Your consent for contacting the patient and also their acknowledgement of the privacy practices should be a second one. A financial policy is not a bad idea, so the patients acknowledge that they're going to be charged for any co-insurance that's required. And that's what we try to limit it to. So if you have any questions on that, you can feel free to contact me offline. Here's my information. For those of you who are not on our listserv, please feel free to sign up. We write twice a week. I write twice a week, every Tuesday and Thursday. Sometimes we have some guest writers or comments or other things published. I open questions and comments on them twice a week. Feel free to submit questions. And I hope you enjoyed today's brief overview. And I thank you for joining us. We'll see you on Wednesday if you're a New York provider and you would like to go over iStop.